Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here.
Oh, okay.
What your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it in the file.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll
sure.
be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
Before we even get into today's chaos, let me set expectations right now. This is not one courtroom meltdown. This is a full sampler platter of sovereign citizen delusion, spread across 5 different courtrooms, multiple judges, and a level of confidence that only exists when someone knows absolutely nothing about the law. We've got repeat offenders who swear the system is scared of them, a man who thinks American national is a legal invisibility cloak, and a custody case where ego is prioritized over actual children. What ties all of these cases together isn't intelligence, evidence, or legal strategy, it's entitlement. Every one of these defendants walks in believing the rules magically stop applying the moment they say the right combination of words. Spoiler alert, they don't. And as we move through these hearings, pay attention to how patience turns into frustration, how calm judges draw hard lines, and how quickly these fantasy arguments collapse when reality shows up. Buckle up, this one escalates fast.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
This right here is why sovereign citizen performances are so dangerous to confuse with incompetence. A lot of viewers originally assumed Walker didn't understand what was happening, but this update proves something far more uncomfortable. He understood just enough to game the system. He played dumb, rejected counsel, leaned into confusion, and still walked away with probation on a level 5 drug felony. That isn't ignorance, that's manipulation. And now we're seeing the consequence of that gamble. Probation isn't freedom, it's a contract. You don't get to selectively participate. You don't get to opt out because paperwork offends you. The moment he chose not to report, the deal collapsed. This is the sovereign citizen cycle in real time. Exploit the system's protections, ignore its responsibilities, then act shocked when enforcement catches up. And notice how calm the judge stays. No lectures, no theatrics, just methodical consequences. This is how the system corrects itself.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't have license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer to send it back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man.
This exchange perfectly captures the sovereign citizen paradox. Walker doesn't want an attorney, doesn't want to waive counsel, and refuses to sign anything, yet expects the court to somehow proceed anyway. That's not how due process works. Courts aren't guessing games. They require consent, acknowledgement, and documentation. When defendants refuse to participate, judges don't get flustered, they get strategic. Appointing standby counsel here is a quiet but powerful move. It protects the defendant's rights despite himself and preserves the record for appeal. Walker thinks refusing to sign gives him leverage. In reality, it removes his ability to later claim confusion or coercion. Every "I'm not signing" moment narrows his options further. Sovereign citizens often believe paperwork is a trap, but legally, refusing paperwork is often the biggest trap of all.
Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You got to follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a license.
I thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Oh, okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to again.
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we've set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right. You don't have a right to either or.
Yes, I do. Of course I do.
Albert Hicks isn't confused. He's confrontational by design. From the moment he opens his mouth, this is about dominance, not law. Notice the language, accusations, challenges, constant interruptions, all meant to destabilize the court's authority. But here's the problem with that strategy. Judges control the pace, the record, and the outcome. Hicks keeps insisting the judge is practicing law from the bench, which is a favorite sovereign talking point that means absolutely nothing in legal reality. Judges don't litigate, they adjudicate. And when Hicks demands credentials, oaths, and proof of jurisdiction, he's not making arguments, he's filibustering. This isn't confidence, it's insecurity masked as bravado. Every interruption burns credibility. Every challenge tightens the judge's grip on the room. And you can feel the patience thinning, not emotionally but procedurally.
All right, I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Chico Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 144, 2547, counts 1, 2, and 3, SP 144, 27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time. You know, basically, you're almost, it's almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
This is the sovereign citizen script hitting its limit. I challenge jurisdiction only works if you can articulate why. Hicks can't, because jurisdiction here is obvious, statutory, and already established. When the judge explains that court rules and the state constitution grant authority, that's the end of the debate. But Hicks keeps talking, and that's the mistake. Courts don't reward repetition. They punish it. The judge isn't offended, he's documenting. Every warning, every interruption, every refusal to follow instructions is being logged. And when the judge says, I'm running this show, that's not ego, that's procedural reality. This courtroom is no longer about guilt or innocence. It's about control, compliance, and whether Hicks can stop sabotaging himself long enough to protect his own interests.
Pay close attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Mr. Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
14 years.
This moment exposes how shallow Hicks' legal understanding really is. He believes constitutional rights mean unlimited choice, bench trial, jury trial, whatever he feels like that day. That's not how rights work. Rights come with frameworks. The judge offering a jury trial isn't denying Hicks anything. He's ensuring constitutional compliance while refusing to indulge chaos. And notice the subtle correction. An actual attorney would already know this. That's not an insult, it's a fact. Self-representation doesn't turn feelings into law. When Hicks resists the jury option, it's because juries don't tolerate nonsense. Judges may entertain arguments for the record. Juries expect coherence. And Hicks knows it.
Honor. So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifuleaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name? What is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
Ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
that would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenged the jurisdiction, and jurisdiction must be
It's
proven.
not going to happen today. Today,
Jurisdiction
you're
must be
here
proven.
to hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting.
This dismissal is going to upset people, and understandably so. Hicks walks out without convictions today. But this isn't a victory, it's a procedural failure by the prosecution. No officers, no case. That's how due process protects everyone, including people we don't like. The judge makes that clear without apologizing for it. But here's the key detail. Dismissal isn't exoneration. It doesn't validate Hicks' behavior, his arguments, or his worldview. And the immediate pivot to a domestic violence case reminds us why procedure matters. Courts must be precise, because power without restraint is far more dangerous than a guilty person temporarily walking free.
It's gotten so bad that I recently caught a retired Michigan family court judge speaking on behalf of a state proposition that would protect judges and their families from undue harassment.
This is not personal to me, that these situations happen. I was a presiding judge of the family court for 8 years. These are conversations I have with my colleagues on a daily basis, talking about how sovereign citizens file UCC statements against us, against our property. We have to have lawyers in our court represent us to remove these filings against us.
Today's hearings perfectly illustrate the difference between rights and recklessness. Sovereign citizens love invoking the Constitution, but consistently ignore the responsibilities that come with it. From Walker's probation gamble to Hicks' courtroom theatrics, the pattern is the same: confidence without competence. Judges don't win arguments, they manage systems. And when defendants refuse to play by the rules, the system still moves forward. Sometimes slower, sometimes imperfectly, but always deliberately. If you found these cases as fascinating, frustrating, or shocking as we did, hit that like button, share your thoughts in the comments, and let us know which courtroom moment stood out the most. And if you want more no-nonsense breakdowns of courtroom chaos, sovereign citizen failures, and legal reality checks, subscribe and stay tuned.
It would just add to that. And I
You
don't
can do
think that
but
you
right
need,
now,
you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.